Good evening, everyone. Welcome to today's talk on the Values Network. We have with us today Advocate Colonel Narendra Dahiya, retired. Sir is practicing in the Armed Force Tribunal, Delhi Principal Bench, and Sir has had a very successful stint with the Armed Forces. He commanded an infantry battalion. He has been a career officer throughout, having served as instructor in three Category A establishments. And now, after his tenure in the armed forces and having sought an PMR, Kaldaya has been practicing in Armed Forces Tribunal Delhi bench and has been helping a lot of ex-servicemen and services officers in the various matters pertaining to service-related or armed forces-related issues. So today we have invited him over to share his expertise with us in especially for the disability issues, disability benefits, etc. I welcome you to the talk, sir.
Thank you so much.
So, sir, I'll start. We have more than 100 people here in the talk. Now we'll start with the questions directly. And my first question to you, sir, and the format would be that I'll ask you questions first. And once my questions are done, then the audience asking their questions. So, who is eligible for a disability pension in the Indian Armed Forces?
See, the criteria for getting disability pension are two. Firstly, your disability has to be more than 20%. In some cases, the courts have been granting disability pension for disability less than 20%, but the requirement as per the policy and rules is that minimum disability has to be 20%. And secondly, the disability has to have a causal effect the military service. That means it should be either attributable to or aggravated by military service. So these are basically two requirements, and the disability is to be decided by the release medical board. So the opinion of release medical boards, which decide your percentage of disability, and they also set forth an opinion regarding whether the disability is attributable to or aggravated by the military service. So the basic condition is 20% disability or more and attributable or aggravated by military service.
So, under the two conditions of having more than 20% disability and having attributable or aggravated by the service conditions, the disability pension is not paid.
So, in case you meet these two conditions, disability pension is paid. Actually, the disability pension, there are two issues, two things, disability pension and disability element. So, a person who retires or invalidated out of service, even after completing his complete service, he is taken as invalidated out of service and he is granted disability pension. Disability pension consists of two elements, the service element and the disability element. So a person, an officer who retires after completing, say, 54 years of service, he will get his service pension full, and he will also get a disability element which will be proportionate to the disability. And the disability is now broadbanded. A disability up to 49% is broadbanded to 50%. A disability from 50% to 75% is broadbanded to 75%. And rest is broadbanded to 100%.
So after the broadbanding, how much is the disability pension paid, sir?
This service pension is 50% of the last pay drawn, and the disability pension 100% is 30% of the last pay drawn. So in case of 15, the disability being 20 to 49%, that is broadbanded to 50%, the pension would be 15% of the last pay drawn. And the second benefit in addition to monetary benefit is that the complete pension is tax-free. You are not required to pay income tax on the complete pension. That is both the service element and the disability element.
My next question would be, sir, is there a provision for increase of the disability pension over a period of time?
The disability pension is given on the RMB which is held at the time of release of an officer or soldier from the army. However, in case he feels that the disability has aggravated, as per the rules, he can apply for one resurvey medical board, only one. Once he can apply, and if the resurvey medical board assesses his medical disability differently, then his disability element would be enhanced accordingly.
Right. So one disability is based on the release medical board, and then there is one possibility if the individual feels that there is an aggravation, a review. Now, are there any other benefits available to military personnel with disabilities, sir? Defense personnel with disabilities?
As I said, firstly, they get the additional pension. Secondly, they get the income tax relief. They are not required to file, they are required to file income tax return, but not required to pay income tax for the service element as well as the disability element. In addition, the Department of Ex-Servicemen Welfare extends additional benefits to the disabled soldiers, which are in terms of providing them additional employment and some ex gratia payment by some of the state governments.
Okay. Sir, how can one apply for disability pension? How can someone who's moving on discharge apply for a disability pension?
Generally, people feel that there is a requirement of applying for a disability pension. But like a service pension, there is no requirement of applying for a disability pension. It is automatically granted. In case an officer or a soldier he is disabled while in service. Disabled means he could be disabled because of an injury or even because of a disease. And if the injury or the disease is attributable to military service or aggravated by military service, his release medical board would be held while he is being invalidated out of service or while he is going on pension from service. So depending on the RMB is forwarded to the Pension Sanctioning Authority. The Pension Sanctioning Authority, based on the disability awarded in the RMB, decides whether the officer or the soldier would be granted disability pension. In case the officer or a soldier is denied a disability pension, the same will be intimated to him by the Pension Sanctioning Authority. In the second paragraph of the letter, they will also intimate the officer or soldier that he has a right to appeal against the decision of the Pension Sanctioning Authority. And he is given 6 months' time to appeal against this decision. So he can appeal against this to the Appellate Committee of First Appeal in the Army Headquarters, which is the Vice Chief of Army Staff. In case the First Appellate Committee of First Appeal also denies him the disability element, they will also intimate him in writing and will give him a chance for a second appeal. That is his right. The letter will mention that you have a right to put forward a second appeal against the decision of the Pension Sanction Authority, and they will give him 6 months for doing so. This is decided by the Ministry of Defense. And after the second appeal is also denied, then he has the option of approaching the Armed Forces Tribunal for grant of the disability pension.
Okay. Sir, can pre-existing disability, personnel with pre-existing disability also apply for disability pension?
At the time of enrollment in the army, all soldiers are expected to be in shape 1 or are in shape 1. But there are certain genetic conditions which are not really checked by the medical boards. So for these genetic conditions, conditions which come up which cannot be detected by the medical boards at the time of entry of a soldier into service, and in case the same is given out in detail by the RMB, the disability pension can be denied to such a soldier in such cases.
Okay. Military person with a disability work after receiving a disability pension. Is there any limitation that they cannot work or they cannot take up a civil employment?
The grant of disability pension in no way debars a soldier from seeking employment in civil or even in the other government departments. So this is basically a welfare measure, a compensation for his physical disability which he suffered because of his service in the army, and there is no bar of any kind on him from serving in the civil sector.
Okay. Sir, can a military person with disability receive any other pension also from some other service he accrues in addition other than his element of pension for the armed forces service, then the disability component, and let's say he goes and works in an organization which further pays him a pension?
So this disability pension will continue to be paid even if he gets a pension from any other department. Like the soldiers who go into DSC, they get two pensions, two service pensions, and continue to get the disability pension. However, two disability pensions are not awarded to them.
Sir, my next question would be, Can disability pension be transferred in the sense like a family pension? Is there any provision of the disability pension being transferred if the individual who is drawing the disability pension dies and there are survivors,
It
depending
is,
survivors?
yeah, that's a very good question. The disability pension is also added to the family pension. In case the soldier dies in service or later on, disability pension is granted to the family also. Disability element of the pension is granted.
Sir, another question which I have been asked by a lot of officers and they want to know about it is how is the disability pension for battle casualties or war wounded covered? Is there any difference in that and the other disability pensions?
The disability suffered during war is called War Injury Pension, WIP. That is paid at a higher scale. In fact, the full salary is paid to the soldier who suffers a war injury pension. So the scale is higher, goes up to 100% of the paid on. That depends on there's a method to it, how a war injury pension is granted. There is a special army order, 1 of 2003, wherein the units are expected to first report the injury in a battle or in operation, specified operation, in a sit rep, and thereafter they are supposed to send an initial report and detailed report to the army headquarters. Army headquarters thereafter classifies the disability as a war injury pension and grants a enhanced disability pension to the tune of 100% salary.
Okay, one more question, sir. Let's say there is an individual, he has, at the time of his release medical board, he has been given a certain disability, but the person is not satisfied with the results of the RMB. Can he appeal against the results of the release medical board?
One resurvey medical board is authorized to the people who undergo a release medical board or any medical board. So they can apply for a resurvey medical board to the nearest MH where the RMB has been carried out to the CO. And the copy of that letter is required to be sent to DG AFMS also. And a decision is to be arrived by them within 1 week. One resurvey medical board is authorized. However, the finding of this resurvey medical board will thereafter be treated as final.
Sir,
Secondly, the disability pension can be granted even after retiring from service. Say in case of a soldier or an officer, he falls sick, say after retirement within 10 years, and in case he can prove that this disability or disease is because of the service conditions or that the disability is now attributable or was aggravated by the military service, he could be granted disability element of pension later on also.
sir, what is the legal position in case the release medical board gives a NAN, non-attributable, non-aggravated, but the individual feels that that is not the case? The injury or the disease was aggravated or is attributable to the service conditions, and what are his relief? What can he or she do to get relief, sir?
There are two views on this subject. One is the view of the courts, and second is the view of the organization. The view of the organization, that means the Indian Army, Indian Navy, and Indian Air Force, or the MOD, is that officers and soldiers who have diseases and not injuries. So people who suffer from diseases are mostly being classified as non-attributable to and not aggravated by military service. Most of the diseases are being classified as such, and the MOD is denying them pension and also turning down their first and second appeal. That is in most of the cases. However, the courts have taken a different. Supreme Court has said, based on the rules of GMO 2002 and 2008, that any disease which comes up in a soldier or an officer while he is serving in the military forces is to be treated as attributable to or aggravated by military service unless the reasons have been given out in details in RMB why such is not being done. So there are two views. Most of the officers or soldiers are getting their disability element through the courts, and unfortunately our organizations are not being very helpful to the soldiers in such matters.
Sir, I have two last questions before I open it to the house. There are a lot of people who want to ask you important questions. One is, sir, in what is the provision for giving disability pension to those who are otherwise not eligible for a service pension, say a short service commission officer or a Jawan who leaves after not completing eligible service but has a disability element? Would they be granted disability pension?
Any officer or soldier who is invalidated out or who leaves the service at any time is supposed to go through a release medical board. And in case the release medical board mentions that he has a disability of more than 20%, and the disability is attributable to or aggravated by military service, he is supposed to be given a service pension consisting of the service element and the disability element, irrespective of number of years of service he has put in the military.
So if there is a short service officer and if he is moving out and there has been a disability, and let us say it is not that the officer is moving out because of getting invalidated, he's completing the tenure of his service, has not been given a permanent commission, but there is a disability. In that case, what pension would be allowed to him? Would it be service element plus disability element or only the disability element?
He will be given both the service element and disability element, invalidated out by the Supreme Court in a judgment, and any soldier who leaves the service after going through RMB and in a low medical category is supposed to be taken as is assumed to have been invalidated out of service. So an SS of the short service commission officer will get a service element as well as a disability element, irrespective of number of years of service he has put in.
Okay, sir, my last question before I open it to audience. What is the position? Let's say there is someone suffered an injury in a battle casualty or a war wounded kind of a situation, say posted in Siachen. The CITRA was initiated, but it did not contain exactly the words of battle casualty or war wounded. The individual also at that point in time did not pay heed to the CITRA, or somehow, I mean, there was a bureaucratic or a clerical lapse. Can he contest and seek his rights in the AFT that the injury was indeed because of the reason of battle casualty or was a war wounded individual, and due to a technicality, the right should not be refused to him or her?
There is a classic case of an officer during Op Prakram. He was in Punjab, but since there was a specified operation going on, Op Prakram, this officer was responsible for having the ammunition loaded and then delivered to the forward positions. And he got hurt in the process of loading of ammunition while he was getting down from a vehicle or something. So this officer was given war injury pension by the courts. The military denied him war injury pension. Similarly, in case of injury suffered during any specified operation, and especially in Siachen, is to be treated as a war injury, and the officer is to be given a war injury pension. Unfortunately, our processes are not correct, and sometimes even our senior commanders are helpful to the officer. They grant him that he has been injured in a warlike situation, recommend grant of war injury pension to him, but it is the CDA rep which sits in the MOD that denies this pension, this war injury pension. So the only way out is for this such officers and soldiers to come to the court and fight for their rights. And most of the time, the courts are helpful and grant them war injury pension.
Thank you so much, sir. Yours have been a very, very informative and relevant discussion.
Gotta focus on yourself, on your faith, on your dreams, on your mind, on your health, yeah. You gotta work, never tell, keep your head